When you win a driver's license restoration case, you have won because you've demonstrated those two key things to the state. Number one, that you've been alcohol-free for a sufficient period of time, and number two, that you have the commitment and ability to remain alcohol-free. To be clear, the state has drawn a line in the sand and said, after multiple DUIs, you're considered risky when it comes to drinking. And the state isn't going to take any more chances. They are never going to consider somebody who says, it was a different time in my life. I don't drink like I used to. I don't drink that much anymore. I only drink on special occasions, or only at home, or only when somebody else is driving. Their take on it is, listen, you have demonstrated that when it comes to alcohol, you are a risk, and a risk to the public as well. Therefore, when we pull a license, revoke a license, after you've racked up multiple DUIs, the only way you're going to get it back is when you can prove to us that you have given up drinking for good, because we know one thing for sure: people who don't drink are precisely zero risk to drink and drive again. So that's the line in the sand. And if a person shows up and so much as even hints that they think they can ever drink again, the state will say no on the license appeal, keep taking the bus or hitching rides or whatever. So it is a necessary precondition to winning a license appeal, and therefore operating with an ignition interlock unit in your car, that you have given up alcohol for good and forever.
Can't you use ignition interlock for a DUI though?
In high BAC cases, an ignition interlock is mandatory as part of the driver's license consequence. A person who's convicted of high BAC will be suspended for 1 year. They'll have to serve what's called a 45-day hard suspension, meaning they cannot drive at all for 45 days, and thereafter may drive for the remaining 10.5 months of that year on a restricted license with an ignition interlock unit installed in the car. In those cases, a person is under orders by a court through probation to not consume alcohol anyway. The interlock unit, of course, first and foremost, in that capacity serves as a protection so that the person doesn't get behind the wheel after drinking, but it also serves as sort of an independent and maybe sort of ancillary verification tool, so that maybe if the person drank a lot the night before and they wake up in the morning, and even though they might not be drunk or over the limit to start the thing, the unit detects alcohol, the court can say, this person isn't remaining sober. They're coming home after work and drinking and thinking they're cutting off in time, but on so many occasions we've seen that they've been drinking anyway. So no, actually you cannot. You can probably get away with it, and of course there are judges. A judge has the ability or the discretion to require an ignition interlock in any OWI or DUI case. So a judge could say to a first offender, fine, but as part of your probation, you need to drive for 60 days or 90 days or an entire year with an ignition interlock. I mean, in theory, it's possible that a judge might not order a person to not drink alcohol, but simply require him or her to not consume alcohol prior to driving. And in fact, that was not uncommon decades ago, where judges would say, you are not to consume any alcohol prior to operating a motor vehicle, but the person while on probation was otherwise allowed to enjoy a glass of wine or something like that with dinner.